In a time where our international legal order is under strain, when action too often evades consequence and headlines fade faster than justice arrives, some people remind us of why the law matters. Our guest today, Philippe Sands, stands at the crossroad of law and history. As a barrister, author, and professor of international law, he has not only argued one of the most consequential cases of our times, but also helps us understand what justice means beyond the courtroom.
Through his books, he's brought to life the origins of a modern legal system, embedding the roots of international crimes in human experience. His writings are not just about the past, they are called to examine the law in its current form and see how it can be transformed. In this interview, we're going to discuss his work on introducing ecocide as a fifth international crime and discuss the law not just as a system, but as a story about the future, power, and responsibility. Please join us in welcoming Philippe Sands.
Where shall I sit?
Yeah,
Over there.
That's good. Thank you very much. Welcome to our couches, Mr. Sands. We'll dive right in.
Great. It's lovely to be here.
Yeah. You started studying international law at a time when it was not at the forefront of public consciousness yet. What would you say are the biggest changes in public perception since then?
So in England, law is an undergraduate course. And I went up to university actually to do economics as an undergraduate. But I'd had a fantastic economics teacher at school. And he'd sort of done it in a more interesting and a more political way than it was being taught at Cambridge. And so I changed after about 6 weeks to law and totally regretted the change. I thought law was really boring, really complicated, had nothing to do with my own situation until I took a course on international law. And I loved international law, I think in part because it connected to my family life. My mum was a refugee, and so I felt somehow a connection with the issues. That was about 1980, so it was a long time ago. And that was still in that period during the Cold War, which we were told had ended in 1990, but plainly has not ended, and continues in some other format. I think the big change is that when I studied international law, it was taught rather conservatively as a system of rules that was of interest to very few people, basically states, governments, international organizations, and didn't connect with everyday life. And I think the transformation that's happened over the last 40 years is that international law has become a subject that touches everyone's life, directly or indirectly, whether in the economic sphere, whether in relation to human rights, whether in relation to war, whether in relation to the environment. And I think it's the growing recognition of the scope of the international rules and the importance of the 1945 moment.
Mm-hmm. You just mentioned that the biggest change in international law has been its connection to the human experience. And you're known for turning legal history into engaging stories. You just recently published another book, 38 Laundry Street, on impunity, Pinochet in England, and a Nazi in Patagonia. We're wondering, why did you choose to approach international law through storytelling?
It's a very good question, and there's a very clear and simple answer. Up until about 2000, 2001, I had only written academic books. I'm a professor at University College London, I'm a barrister, I do cases, and that was the life that I had, and it was a good life. And I loved that life of basically teaching, writing academic articles, books, and doing cases at the International Court of Justice. So I spent a lot of time in The Hague, not far from here. And then the world sort of changed on its axis with the events of September the 11th, 2001. I happened to be in New York on that day. I was teaching at NYU Law School. I remember the day very well, a very shocking day. And that set in train a series of events. And one of the events, of course, was the war in Iraq. And That was a war that I was opposed to on legal grounds and also on political grounds. I thought it was stupid and I thought it was unlawful. But also with my family, we had 3 young kids at that point, we went on a march in the centre of London. And British people don't march a lot. It's very rare. And for 1.5 million Brits to turn up on the streets of London, it's got to be special. And what was really interesting about that was that a lot of the people were carrying handmade sort of placards, which they'd done themselves. And many of those placards had rules of international law on them. And I thought, gosh, this is really interesting that regular folk from across the spectrum, all kinds of different people, all of a sudden are interested in the rules of international law, which say you can't use force, you can't use military force consistently with international law. And that experience provoked me into writing the first book that I wrote, which was for a general audience in English. It's called a trade publication rather than an academic publication, which was a book called Lawless World, which dealt with the illegality of the war in Iraq. And so I went from happily doing my books for Cambridge University Press, Oxford University Press, which I love, which would sell, 12 copies and be read by 18 people, to suddenly selling books that sold 30, 40,000 copies and reaching a much bigger audience. And what happened was that it taught me that experience, that there are a lot of smart people out there who are not lawyers, who are certainly not international lawyers, who care a lot about this international system and issues of justice and issues of accountability and rules. And I decided I would change direction and start writing books for a bigger audience. I wrote 2 that were still with a sort of an academic bent. I'm kept out of the book. You don't hear my voice in Lawless World. You don't hear my voice in Torture Team. The book that changed everything was this one, was East-West Street, because I had an editor in New York, a wonderful Victoria Wilson, who basically encouraged me to put myself into the story. As an academic and as a barrister, you don't do that. Your students don't care about your personal experiences, so we thought, and judges certainly don't care about your personal opinions about things, the judges of the International Court. And so she encouraged me to put myself in the story and to focus on the human side. One of the bits of advice that she gave me, which was brilliant advice, she says, your readers are very intelligent. They are interested not only on what you have discovered, but how you have discovered it and the people that you've encountered. And so I began to draw pictures of the characters that I was encountering. And I was able to do that because one of the things that you do when you're a lawyer doing cases at the International Court is you spend day after day after day sitting there. It's like I'm looking at you guys, and you sort of watch what people are doing. My wonderful colleague James Crawford, no longer with us, sadly, I remember on my first case, said to me, Philippe, you will be doing incredibly well in your oral arguments if after 20 minutes the Chinese and Russian judges are still both awake. And it's those sort of little points of detail that you begin to pick up. And so peppered in East-West Street and 38 Londres and the Rat Line are now much more literary styles of writing about the individuals that I'm dealing with.
Yeah. And the cases you describe in your book are often quite politically salient. And if we look at, for example, the current investigation of Netanyahu, he accuses the ICC of political bias, and state actors like the US shield him. How can international law accommodate the political reality of justice?
Sure. So when I studied law, which started in 1979, I'm pretty ancient, we were sort of taught, actually just out of interest, how many people here are law students? Okay, so quite a lot of you. So I don't know how it is for you lot, but for me, we were sort of taught there's law and there's politics, and the two are completely separate. That was the Cambridge style of teaching. The judges are neutral, they don't do politics, they just do the law, they just do the facts, the law. And then I went and spent a year in America, and it was a very torrid period. I spent a year as a visiting scholar at Harvard Law School during the rise of critical legal studies. And there it was a completely different. There, everyone on that side of the spectrum was being taught law is politics, politics is law. And so it was a sort of confusing but interesting time. And of course, I've come to understand that the separation between law and politics is artificial. Every judge who sits on a case at the International Court of Justice has a background, has a culture, has an ideology, has their own personal backstory, and they bring to the process of judging all of those personal traits. I sit as an international arbitrator, and of course, I'm acutely conscious that I bring to the process of judging or arguing before an international court my own personal predispositions. You cannot separate them out completely. You seek to separate them out to the extent that you can. And I think in these times, as we've come to understand the relationship between law and politics and the intertwining and the interconnections, it becomes easier and easier to say, oh, well, it's just politics. But it isn't just politics. I mean, the decision of the prosecutor to indict first Vladimir Putin, then people from Hamas, then people from the Israeli government, went through a process. And that process was not arbitrary, and it was not discriminatory, and it was not racist. It could have been done in different ways. It could have been done secretly. It wasn't done secretly. But it went through a process. It was not a purely political act. It had to take into account facts on the ground. It had to take into account issues of jurisdiction. And it had to take into account the prosecutor's determination, because prosecutors don't want to bring cases they're going to lose, that there was a reasonable prospect of success. And that throws up lots of complexity. So, for example, you'll be aware of the well-known case brought by South Africa against Israel alleging genocide under the 1948 Genocide Convention. But interestingly, the prosecutor of the International Criminal Court, who has a discretion as to which crimes to indict for, had three possible crimes he could indict Mr. Netanyahu for: war crimes, crimes against humanity, and genocide. And he went for war crimes and crimes against humanity, not genocide. For the very simple reason, I suspect, I don't know, I haven't talked about it with him, that to prove genocide is very difficult before international courts, whereas proving war crimes and crimes against humanity is much easier. And so you've got two international courts that are going in different directions, and as these cases evolve, it will be curious to see how they connect. So it's not that law is politics, but all law has a political element, because ultimately you're taking a text, which is usually called a law or a regulation, and you are interpreting it, and how you interpret it is open to various techniques. We've got this issue right now. We're having a huge discussion within our family, two parents, a mum, a dad, and three kids, on a judgment this past week of the Supreme Court in Britain, which has had to interpret the Equalities Act and give a binding legal interpretation on the meaning of the word woman in the Equalities Act. Is woman biological, or does it include a trans woman? And they've come down with a judgment which says, on the interpretation of this statute, it's biological, does not include trans women. This has a lot of consequences. So the debate within the family, as within any community, is how did the judges go about doing it? How do they interpret, and so on and so forth. You can't say there is no politics in it, but it's not pure politics.
Law and politics, from what you just said, are, however, linked.
Of course.
And every legal statute specifically is also dependent on legitimacy and justification. And international law seems that it's made in a context of geopolitical realities and elite decision-making, where there are no global voters that are affirming these laws compared to where you can say in a national jurisdiction, there's at least a voter base that affirms them. If international law is not grounded in our understanding of democratic legitimacy, what gives it its authority?
So one of the critiques of the system of international law is its absence of democratic legitimacy. None of you have, in a direct way, participated in a decision of whether to make a particular law. You don't have representatives in your parliament or in your Senate who are negotiating the international treaties. It's essentially an executive act, which in some countries, not the United Kingdom, has to come back to Parliament to be approved. In the United States, it has to be approved by 2/3 of the Senate or 60 members of the Senate, and that's why so few international treaties are adopted. So it's certainly the case that international laws, I'm thinking of the Genocide Convention in 1948 or even the United Nations Charter, are adopted by governments, and their legitimacy in the political sense, as well as in the legal sense, is derived from an assumption that the government of a state represents the population of that country, and that's the source of legitimacy. But it is not directly connected, as in a domestic law, with any of you, with me, with us. It's an indirect source of legitimacy. But the fact is, whatever attacks there are on international law, it's all we've got. The alternative is mayhem. The alternative is a return to pure power politics. And that was brought home to me very acutely 5 years ago. I'm still involved in the case brought by the Gambia against Myanmar in relation to allegations of genocide of the Rohingya community. And we had a provisional measures phase. I'm for the Gambia. And for Myanmar, they were represented by Aung San Suu Kyi, as you know, winner of the Nobel Prize for Peace. And she defended what had happened in Myanmar. I sat this distance from her. I didn't like much of what she said, but she said one thing that was really interesting, I thought, which was international law is the only language we all have in common. And I thought that was really interesting. It's a way of communicating, and that's what's happening between Ukraine and Russia today. It's also a way of communicating between Palestine and Israel. It's also a way of communicating in Sudan or in Myanmar or wherever. People will have different interpretations of the rules, what they mean, how they're to be applied, but it is a common language, and that, I think, plays a really important social function.
Yeah. And right now we're seeing increasing global pushback against this international institution, one could say.
Yeah.
Do you feel like international law is facing a crisis of legitimacy as a language?
I wouldn't say a crisis of legitimacy, but it's plain that it's facing real challenges right now. In particular, the shift of position of the United States under the government of Mr. Trump has turned its back on the system of rules that was put in place in 1945. The system of multilateral institutions, the idea of an international rule of law. And of course, we don't know how long that will last in the United States. The United States has always sort of had a sort of complex relationship with international rules. It's sort of international rules for others, but not for us. And so for the moment, that particular country seems to have turned its back against the ideas of 1945 of individual rights under human rights law, group rights in relation to the Genocide Convention. But nature abhors a vacuum, and other countries and communities step in, and the Europeans are stepping in, the Brazilians are stepping in, the South Africans are stepping in. The Chinese, in relation to some international rules, have stepped in. It's simply not right to say that China is against the rule of law. It's not. There's no country that is more committed to rules in the economic sphere than China. The global free trade rules, rules on foreign investments, and so on and so forth, because that country is so exposed internationally and so dependent on predictability and certainty and security. And so when Mr. Trump announces, 1,000% tariffs or whatever on China, China doesn't react by going to war or only retaliating. It brings a case before the WTO for violation of the international trade rules. And that's what the European Union will do. And the simple point is that international justice is a long game. You can't expect the rules to be changed in 1945 and then everyone keels over and says, oh, okay, we give up, we're going to follow all of the rules. And I take my inspiration from this. When I was a young academic in the mid-1980s as a research fellow at St. Catherine's College, Cambridge, the college had I had a colleague at the college, a professor of English legal history, Sir John Baker, And he would say, he'd invite me to lunch from time to time and say, what are you working on, Philippe? And I'd tell him what I was working on and stroke his little beard, and he'd say, yes. We had a similar problem in English law in 1472, and it took 275 years to sort it out. And that is where we are on international law, frankly. It's just a long game, and we're just at a very early stage, and bit by bit, one step forward, one step sideways, another step forward, one step backwards, it gets put in place. In Holland, you know this as well as anyone, the system of rules takes decades, takes centuries to nurture, to develop, to be built on, to the foundations to become established. And then we see in the United States right now that even when it's been around for a couple of hundred years, all of a sudden a new president can come along and say, I don't accept this anymore. And right now you have a crisis in the United States in relation to this guy who's been deported to El Salvador, because it seems for the first time, you have an administration which is not going to do what the Supreme Court has told it to do, namely to facilitate the return of this fellow from El Salvador to the United States. In the end, the rule of law will prevail. I've got no doubt about that, as it did in Germany after the events of 1933 to 1945. But it's a long game, and it's not linear. It's sort of, like this.
As you just mentioned that the US is seemingly retreating right now and that other players have to step up in the international order, you previously mentioned that international was an Anglo-American character, even though the changes in international law take centuries. Do you think that currently we could potentially perceive a change in this Anglo-American character?
Yeah. No, I think it's not that international law has an Anglo-American character, it's that the 1945 moment has an Anglo-American character. And it was not exclusively done by the British and the Americans, but they pretty much led the way with support from the Soviet Union, various European countries, Australia, Canada, but it's a very northern settlement, the 1945 settlement, and plainly that is changing. And the real way, I think, to understand what is happening right now, from my perspective, is that those days are over. The world is changing, and we're seeing new powers rise in the South, China, Brazil, South Africa, various other countries, and they're not saying we're going to throw away the old system. They're saying we're going to transform the old system. It's going to evolve over time, take into account our values. And we here, sitting in a European context, have to recognize that for 300 years, the Europeans have played a disproportionately large role in the design and implementation of the international order, and that is changing, and we need to accept that and not resist it and go along with it and contribute to the changes. And in a sense, looking on the bright side, I tend to be a positive person despite my real concerns about the state of the world right now. The arrival of Trump, you could see as having a silver lining. It has been like a sort of stab in the arm for the Canadians, for the Mexicans, who've reacted really firmly and strongly, and for the Europeans, who frankly are pretty bloody complacent and suddenly are having to realize, whoa, we are no longer under this sort of protective umbrella. We've got to look after ourselves. We've got to start thinking about our own defense. We've got to start thinking about how we look after ourselves. We've got to think about how we promote our own values. Someone from Ghana said to me in relation to Trump, and they're right, one of the things that they're really enjoying in large parts of Africa is that the Europeans are getting a taste of their own medicine in relation to the kind of behaviors they've had for decades in relation to countries from Global South. All of a sudden, the United States has turned on them and completely done them in, just knifed them in the bag. And that's what Europeans have done for decades in relation to the countries of the Global South. So looking on the bright side, it's a wake-up call, and we should take that positively, not negatively, and think about our value system, think about our legacy, and use it to change our relationship with the world. And I think it's a very important moment. I don't like the way Mr. Trump is doing his stuff. But one has to recognize that in relation to what he's doing, it's a wake-up call, and that's never a bad thing.
I think this is a good moment to turn to the audience for the first time. If anyone has a question, someone will come around with a microphone. Just please raise your hand.
And don't be scared to ask questions. I'm not a scary person.
Yeah, in the white sweater.
Okay. Thank you so much for this interview so far. I have one question that's regarding this joining of politics and law and how they influence each other, especially with the news today with like India and Pakistan. I was wondering about how the international law processes in courts and their verdicts seem to be kind of like a slap on the wrist sometimes for more nuclear powers, such as like Pakistan, India, China, Russia, Israel, America. Like these states seem to be, yes, we need to make them comply, but the conversation seems to kind of shirk away when there is a mention of like, oh, okay, but we shouldn't be too harsh because what if they just kind of explode everything? And I was wondering if you could kind of maybe give some hope or some solution to that conversation or how to go about that issue.
Sure. Well, I mean, we all need a bit of hope, and it is true that, well, as the French writer Balzac put it, the law is like a spider's web in which the small flies get caught and the big flies somehow make their way through unscathed. There is an element of that. But it's not just like that. In my own career, to give you just two examples that really stand out, 1998, when the Supreme Court in London, the House of Lords as it was then called, ruled that General Augusto Pinochet did not have immunity for international crimes committed as official acts while he was in office. That was a really landmark moment. It was the most important moment, I think, in international criminal law since the Nuremberg proceedings. And it basically said, if you are the head of state of any country, even Chile, friend of Margaret Thatcher's, thinking you are protected, and you cross a line, you are at risk of being subjected to the law. And that ruling has had profound consequences in relation to former, even current serving heads of state in relation to their international travels. And the second example that I'd give is in relation to one of the books that I've written. The book is called The Last Colony, and it takes the case of Britain's last colony in Africa, which is called the Chagos Archipelago. The British call it the British Indian Ocean Territory. And I was counsel for many years for Mauritius in leading the proceedings which were ultimately successful at the International Court of Justice, which determined that Britain's occupation of the Chagos Archipelago since 1965 was illegal and that the United Kingdom had to leave forthwith. That decision came down in February 2019. The immediate reaction of the British and American governments was basically to say, fuck off, we're not listening to these stupid decisions. But what's happened? Last October, Mauritius and the United Kingdom concluded an international agreement. I was part of the negotiating team to give effect to the ruling decision of the International Court of Justice. And just a month ago, perhaps almost amazingly, Donald Trump announced that he was comfortable with the decision that had been taken, notwithstanding there is a major US military base on Diego Garcia, one of the many islands of the Chagos Archipelago. And with that decision and with that agreement, once it comes into effect, the Chagosians who were forcibly deported and removed will be able to return. And that is only because of international law. And that indicates that even the great powers are subject to international rules in certain circumstances. It's why I say it's a long game. It's why I say that even though right now I'm extremely concerned and anxious about the state of the world and the state of the international rules and international organizations, over the longer term, I'm optimistic. And for the law students amongst you who are going to throw yourself into this world, you have really important work to do. It's about nurturing the rules, nurturing the system, sticking up for values you care about, and ensuring that as it evolves, it picks up not only on the disasters of international law, and there are plenty of those. We see them on our screens in relation to Ukraine and Russia, in relation to Palestine and Gaza and Israel, in relation to Sudan, right now, which no one talks about, Sudan, but the worst horrors are happening there, and also in relation to our system of environment and the need to, protect the environment using international rules. So I'm not saying it's easy, but there are grounds for optimism.
Yeah. Let's see if we have a second question right now. Otherwise, there will also be a second round of audience questions. The young man in the back, maybe, with the blue jacket.
Thank you. Thank you for the interesting and thoughtful interview. The question I had was about the Manning memo, which is something I think you first published. It was
about what?
The Manning memo of the meeting between Bush and Blair.
Yes,
because the question relates to the legitimacy of international law. Because of course, recently we've seen that Trump's making all these statements. He's moving away from international law. But this is rhetoric. If we look at the earlier actions of earlier US presidents, can we say that they undermine the legitimacy of the international rule of law more with their concrete actions than just their rhetoric?
I mean, I think every country in the world has a sort of two-faced attitude in relation to international rules. Show me a country that is without any hypocrisy in terms of the rules, and I'd be amazed. And the US, of course, we pay particular attention to because it is so powerful, because it has such a significant role in forming the international rules in 1945, and because it has had such a significant role in breaking some of those rules, not least in relation to Iraq and in relation to the decision to use force to remove Saddam Hussein from power. The Manning memo that you refer to is a memo written in the context of the Iraq war, where it becomes very, very clear that the British went in to support that war in circumstances in which they had been advised that to do so was manifestly unlawful. And I think 20 years on from that war, there aren't many people I know who still argue that it was justified by international rules. And of course, most amazingly, one of the biggest critiques of that war is Donald Trump today, who has described it as wrong and unlawful, as has his, I'm certainly not a fan of his vice president, but his vice president has done the same thing. So these things go around in different ways. I wouldn't want to hold any one country to a different standard than any other country. The US supports some rules, it breaks some rules. Britain supports some rules, it breaks some rules. China supports some rules, it breaks some rules. Israel supports some rules, it breaks some rules. I mean, it's just across the board. And I think our role as commentators, as lawyers, as academics, is to point out these inconsistencies and these double standards and these hypocrisies. But I don't think the United States has been notably worse than many others. I mean, there is hypocrisy all around. Russia bombs the hell out of civilian targets in Ukraine and then sends the foreign minister to South Africa to complain about Israel's bombing of civilian targets in Gaza and other parts of Palestine. South Africa brings a case against Israel alleging genocide, but passes in complete silence about the killing of civilians in Ukraine. So how do you explain these double standards? I mean, they're everywhere, and our job is simply to call them out, irrespective of who is responsible for them.
Yeah, thank you for your question. To move back, you just talked about the inconsistencies, and for example, in 2022, Joe Biden called the war in Ukraine a genocide while avoiding to use the same term for what is happening in Gaza.
Yeah.
When a head of state like Biden calls something a genocide but the legal threshold isn't met, or there is this inconsistency, what damage does that do to justice?
So there are 3 international crimes. War crimes, which have been around since at least the middle of the 19th century, crimes against humanity, which is about the destruction of individuals, and genocide, which is about the destruction of groups. And all effectively came into broad public consciousness in 1945. All were part of the famous Nuremberg trial. My book, East West Street, tells how the 2 new concepts invented in 1945, crimes against humanity and genocide, came about. 2 lawyers who happened to come from the Ukrainian city of Lviv. And over the intervening 80 years, something interesting has happened, which is that the crime of genocide has emerged in public consciousness as the most significant of all of the crimes. It isn't the most significant for me. If you kill 100,000 people, I don't care whether you call it a war crime, a crime against humanity, or genocide, it's plainly wrong. To give you an example of the absurdity of the hierarchy that has emerged and why I have a problem with this hierarchy. I serve on an advisory committee for International Holocaust Memorial Day in the UK. And in the UK version of that process, there is a marking not only of the Holocaust, 33 to 45, but of other acts of mass murder. And I asked rather innocently, I remember at one of the meetings, how do you decide which other acts of mass murder you're going to choose? And they said, well, we have a process. The Foreign Office in London has helped us. And that, of course, immediately makes you suspicious about what the process is. And what the Foreign Office advice was, firstly, it has to have happened after 1945. Very convenient for the British. Colonialism's out, slavery's out, all of the crimes of this kind, we can forget about those. And secondly, there must have been a determination by an international court that the crime of genocide has occurred. So I said, okay, I understand that, but let's just tease out what that means. So you will mark the killing of 8,000 Bosnian Muslim men in Srebrenica, which was characterized by the Yugoslav tribunal as a genocide, but you will pass in silence on the killing of 3 million human beings in the Democratic Republic of Congo at about the same time, because that's only a crime against humanity. Correct. I mean, that's absurd. Why would you put, however terrible is the killing in Srebrenica, that story on a pedestal and then pass in silence on the mass murder of 3 million human beings? Why is that a socially useful thing to do? How do you feel if you're the descendant of one of those 3 million people? We don't care about you because it's not a genocide. It's absurd. It's absurd. I don't know why genocide has gone to the top of the ladder in this way. It wasn't Raphael Lemkin's intention. I think the reason is that in part, the idea of the killing of a group somehow inspires a psychological reaction that is stronger than the killing of the same number of people just as individuals. And secondly, I think the word genocide has a less legal, technical feel to it. It evokes, in our imaginations, a picture of abject horror. Pause for a moment. There is a vast gulf between popular understanding of what genocide is, which is basically doing nasty things to a large number of people, and the legal definition as applied by the International Court of Justice and the International Criminal Court. And therein is where a lot of mischief lies. And there is another issue which is causing a lot of difficulty, which is the only way you can get a case of mass murder to the International Court of Justice in The Hague is to call it genocide. Why? There is a 1948 convention on the prevention and punishment of genocide, which gives the court jurisdiction. There's no equivalent treaty that gives the court jurisdiction for crimes against humanity or war crimes. So if you want to argue your case at the ICJ in The Hague, you've got to call it a genocide. There's no way to get there if it's a war crime or a crime against humanity. And this has completely skewed the legal order and the legal process and created immense problems and difficulties for the judges at the ICJ, who have jurisdiction over only one of the international crimes and not the other two. And so when President Biden calls what happened in Bucha a genocide, it's on the front page of every newspaper in the world. In fact, I don't know whether what happened in Bucha meets the legal definition of genocide. I wrote an op-ed piece in the New York Times the next day which said, I think when President Biden used that expression, he was using it in a political sense, not in its strictly legal sense, because we don't know what happened on the ground. We still don't know exactly what happened on the ground, and it takes time to understand. And yet President Biden knew that if he called it a war crime or a crime against humanity, no one would cover it. So the G word brings maximum attention and it brings maximum difficulties. And I'm sort of sad and uncomfortable that the legal order has been skewed in this way and causes so much difficulties. But it reminds us of the importance of language and words in our culture and in our ordinary day lives. The bottom line for me, just to be clear, the killing of large numbers of human beings unlawfully is wrong and is to be condemned, whether it is called a war crime, a crime against humanity, or genocide. And for me, there is no hierarchy between these three categories of international crimes. They are all equally disgusting and terrible.
Stay on the point of genocide for a second longer. If our current definition hinders legal accountability and skews the legal system or legal international system, in your opinion, is there anything like a feasible alternative that we can have?
Yes, there is, absolutely. I mean, if you go back to 1945 and look at the original work of Raphael Lemkin, he set the bar very low in the definition of genocide. For Raphael Lemkin, if you had a single village of 9 people and they came from 3 different groups, and Group A and Group B ganged up on the 3 people from Group C and killed the 3 people from Group C, for Raphael Lemkin, that was a genocide. I have no doubt that if Raphael Lemkin were with us today, he would describe what happened on October the 7th in Israel as a genocide, and he would describe what has happened subsequently in Gaza as a genocide. But Raphael Lemkin's definition with its low bar was not adopted by states in 1948. They inserted into the definition various words which has had the effect of raising the bar much, much higher, including the requirement that you have to prove an intention to destroy a group in whole or in part. And that requirement has subsequently been interpreted by the judges of the International Court of Justice to all intents and purposes as meaning it must be the only intention. And that's almost impossible to prove. If you're using force in self-defense as well as to destroy a group, that's not genocide on that definition. And that, to my mind, is wrong. In the case of Croatia versus Serbia, I argued on behalf of Croatia before the court in relation to the killings at Vukovar that this was a genocide under international law. And I encouraged the judges to revisit what they had decided in the Bosnia-Serbia case, which had set the bar for the definition of genocide very high, and the court just swept it away. And they swept it away in part, I suspect, you'd have to ask the judges, because they believed that if you lower the bar on the definition of genocide, you're going to get more and more cases where wars are being fought, of allegations of genocide being brought to the court, and they don't want the floodgates to open. But the consequence of that is the risk of rendering the 1948 Convention on Genocide a dead letter. So my solution to this is to go back to Lemkin's definition, to lower the bar, the consequence of which is we'd have a lot more genocides in the world. The reification of the word would be transformed, because it happened much more often, as Lemkin believed it did. For him, it was not an exceptional act. There were many acts. For him, thousands of acts over history which were characterized as genocide. But the judges, and I can understand why they do that, are really worried about opening the floodgates. So the answer to your question is in the future definition of the term, and it is possible to change it and bring more things within the scope, but the consequence of doing that is you're going to have a lot more cases, and some people don't want that to happen.
Mm-hmm. Staying on the topic of widening the scope of international law, 15 years ago, the Deepwater Horizon oil spill led to 11 workers dying and over 200 million gallons of oil in the ocean, with an immense destructive effect on marine ecosystems. And the US legal response to this was only financial, with billions in fines and settlements, even though the company in charge of sealing the well knew that it would fail. Was this an indicator that our legal framework doesn't give enough attention to the environmental destruction?
It was one of the many indicators. I mean, as some of you will know, I got my start in life, in my mid-20s, because of the Chernobyl accident, doing work on a subject that did not exist when I was a student, international environmental law. So I've always been very engaged in the protection of the environment. And over time, I've got more and more engaged. And in 2020, I was asked to co-chair with a Senegalese distinguished jurist a working group to come up with a definition of ecocide, which would be a fifth crime added to the jurisdiction of the International Criminal Court. Now, I've talked a little bit about international crimes. One of the things that war crimes, crimes against humanity, genocide, the crime of aggression all have in common is they are concerned with the protection of the human. And basically, international criminal law doesn't deal with the protection of the environment as an end in itself. In other words, saying that harming the environment on a massive scale is a crime under international law. And that's what the crime of ecocide is about. And I think it's going to be your generation's crime. It's going to happen. There are more and more countries that are now coming on board and recognizing that it needs to happen. But it's a very generational thing. When the Guardian newspaper wrote an article in 2020, 2021 saying that I was co-chairing this working group on coming up with the definition of ecocide, the only time our three kids have written to me, sent me WhatsApp messages separately, they didn't even consult, and said, "Oh, just saw this article, finally you're doing something useful." And I understood what they were saying, that for your generation, the environment is a really big issue. And actually for me too, it's a really big issue. I mean, I worry a lot about Trump and Putin and Netanyahu and Hamas and what's going on in the world. But actually, ask me the question, what do I worry about the most? Is climate change. Because I think climate change is going to wreak havoc on a scale that we cannot even begin to imagine. And I think of all the things that is being done by the Trump administration that I find so worrisome, few, if any, are up with what's happening on climate change and the sort of gutting the American legal and institutional system's commitment to addressing emissions of greenhouse gases. I mean, this is plainly now happening. Global warming is happening. We know that it's happening. There is multiple evidence. I see it for myself. I'm a gardener. I see it in our garden with patterns of rainfall and temperatures and what's happening with plants and what's happening with insects. And you go around the world and you speak to people and you begin to understand the scale of what is happening. And the law must have a response to that, partly regulatory. There's just been an advisory opinion procedure at the International Court of Justice. And I'm not starry-eyed about the criminal law, but one of the things the criminal law can do is to say that if you as an individual have the power to do something and you do nothing, you are exposing yourself not to the crime of war crimes, crimes against humanity, or genocide, but to the crime of ecocide. So I think for your generation, this is where the rubber hits the road, and I think it's incredibly important.
But if your proposal of ecocide is placed in the forum of international criminal law, will it not be subject to the same limitations that we discussed earlier?
Absolutely. And, you know, carved on my brain is the experience of Raphael Lemkin with his definition of genocide. I mean, Lemkin was an incredibly well-intentioned human being. Lemkin's role has long been well known, but I think Lemkin's relationship with the city of Lviv and Ukraine was not well known. And I'm very excited that on 24th of June, I will go to Lviv and attend a ceremony at which a street will be named and a whole sector of Lviv will be named after Raphael Lemkin. And his role has been incredibly positive. In 1948, when the Convention on Genocide was being negotiated, he came to a crossroads. Governments, states did not accept his definition. They raised the threshold, they raised the bar. And he faced a difficulty. You walk away from your lifetime's work, or you say the best is the enemy of the good, and you accept the changes, and you support the emergence of a genocide convention which has a definition of genocide which is not the one you would have wanted. And this is a really complex issue, and I'd invite each of you to reflect, what would you have done in those circumstances? And to reflect equally, what would you do in 5 years' time when states say, okay, we're going to amend the Rome Statute of the International Criminal Court, and we're going to have a definition of genocide, of ecocide, but we're not going to, we don't like the definition that Sands and his colleagues came up with because it sets the bar too low. So we're going to put in our own definition, which sets the bar much higher. What do? Do I walk away from it and say, no, I don't accept it? Or do I say, no, the best is the enemy of the good. It's better to start with something and build on that, even though we're all aware of what's happened with genocide subsequently. And this is something you're going to face in your lives. You face it already in your lives. You are in a situation of dispute with someone, a friend, a family member, and you need to find a compromise to move things forward. You dig in your heels and say, no, I'm not budging. This is all I accept. Or do you listen to the other side? This is a complexity of human existence and of life and of social relations. And I think reasonable people can disagree. Some people would say, no, Lemkin should have stuck to his position and walked away. This is not my definition of genocide. Other people say, no, he was absolutely right to get it on. We've got it right now. The world is on the cusp of adopting the first statute for an international criminal tribunal for the crime of aggression since Nuremberg. I can tell you it's going to happen. The texts have been adopted. It's now a political matter as to whether states sign on the dotted line to create a special tribunal for the crime of aggression. On a special tribunal for the crime of aggression, the most powerful countries in the world may be willing to go along with it. But it connects to my new book on Pinochet and immunity. They say, we're a bit worried about the idea that a serving head of state would lose their immunity, because under international law, they have an absolute immunity. And so Mr. Zelensky faces a question. Is it better to stick to my position and have a special tribunal for the crime of aggression in which Mr. Putin has no immunity? Or, if that's not possible, to have a special tribunal where you maintain immunity for serving heads of state? And he will have to decide whether the best is the enemy of the good, or to walk away from a special tribunal. These are really complicated issues, and they do not admit of simple answers. And I think I can see from your faces you understand exactly what I'm saying. We all face this in our own lives. Do we want the absolute position that we're arguing for, or are we willing to compromise in order to move things forward? And reasonable people can disagree on these issues. And I would never criticize someone for taking a different position from my own position, which is generally in response to your excellent question. Let's get something on the table. Let there then be criticisms in 70 years' time of what we have done, and let's then refashion it. But that, I think, is the reasonable way to go for me. But I respect alternative views, of course.
Yeah. Before we wrap up the interview, if there's one more question in the audience, this is your chance to ask it. Yeah, maybe here in the front.
Thank you so much for sharing your expertise with us. About what you were just talking about with the definition of genocide, I was curious about these negotiations, what we know about different states and what their objections were at the time.
We know quite a lot. I mean, the negotiating history, which is called the Travaux Préparatoires, is all available. And we know, for example, coming back to a question that was posed earlier about the United States, that the United States was totally opposed to the concept of genocide, even as it was negotiated in the 1948 Convention, because they worried that the term genocide would be used in relation to US treatment of African Americans, of American indigenous communities, and so they did not sign the Genocide Convention. They didn't ratify the Genocide Convention until 40 years after it had been adopted. And we know from the negotiating history that many countries were concerned that if you set the bar too low, things will be characterized as genocide, which could expose them to legal difficulties and to cases being brought. One of the things that they assumed was that the definition of genocide would only apply prospectively to acts occurring after 1948. But there are developments right now which have changed that picture, and within the last couple of years, one of the most significant developments, so for example, the position of the Turkish government is that what happened in 1915 in relation to the Armenian community cannot be characterized as genocide because the term genocide did not exist in 1915. And that is their position. They accept and recognize there were mass killings. And they will even accept and recognize that you can characterize it as a crime under international law, but not as a genocide. But 2 years ago, Germany recognized the killings of the Herero community in what had been called German Southwest Africa, today Namibia, as a genocide. That's very significant because what they've effectively done is opened the door to a recognition that something that happened in 1908 and 1909 can be characterized as a genocide under international law today with continuing consequences. And if you go back to 1908, why not 1808? Why not 1708? Why not 1408? And you begin to see how the door gets opened in this particular way. But those are the kinds of concerns that states have when they're negotiating treaties. So right now, finally, 80 years after the Genocide Convention was adopted, states have finally agreed to start negotiations on a parallel convention on crimes against humanity, which would do for crimes against humanity what the 48 Convention did for genocide. But of course, countries have seen the experience with the Genocide Convention, and I suspect that quite a few of them, including the larger and more powerful countries, will say, what? I mean, why on earth are we going to agree to a convention on crimes against humanity when we've seen the door opening to international cases on genocide Why would we expose ourselves to those kinds of risks? So the vast majority of countries now wish to proceed with a negotiation on a convention on crimes against humanity, but there's some significant and powerful countries that are really opposed to a convention on crimes against humanity, period. Not a modified convention, not a lesser convention. They just don't want a convention because of the risk that it exposes them to. And that's where I think public opinion becomes really significant. And that's where the works of students and activists and other folks is really significant in providing support for such initiatives, even if it means that what emerges finally in 3 years or 4 years in a negotiation is not the perfect convention by my standards, but is a lot better than nothing. And it brings us back to this question of what compromises are we willing to make in order to create an embryonic legal order which recognizes the rights of individuals and groups.
As we're coming to the end of this interview, you paraphrased Martin Luther King Jr. as saying that the arc of legal history is long, but it bends towards justice. Looking ahead, where do you see the next real test of international justice, and what do you think will it take not to fail it?
I think we're living through it. We're living through it in relation, I've mentioned some of the things that are going on, whether it's tariffs, whether it's Ukraine, whether it's Israel-Palestine, whether it's Sudan. We're living through a moment where at some point we're going to have to settle these horrors. And the question then becomes, on what basis do we settle these horrors? Frankly, we're living it right today in relation to the idea of a peace agreement between Russia and Ukraine. You've seen the news this morning. The United States wants, apparently, according to news reports, Ukraine to accept that the occupation by Russia of Crimea is lawful and that Crimea is to be treated as a part of the territory of Russia. And Ukraine is just saying, sorry, we just cannot accept that. It is not part of the territory of Russia. It is part of the territory of Ukraine. Our constitution so provides. It has always been recognized under international law for the last 70 years, and we're not willing to make that concession. And so that is an example of where the rubber hits the road on respect for the rule of law. And you should be asking yourself the question, as I'm sure many of you are, what does a compromise look like in those circumstances? You can see that Ukraine may be able to accept a situation in which a peace plan recognizes a de facto occupation. Russians are occupying certain areas. But a de jure occupation, is that something Ukraine can accept? And relatedly, on the other side of the story, we know that one of the conditions for peace for Russia is that all issues of international criminal justice are taken off the agenda. No special tribunal for the crime of aggression, no ICC investigations, no criminal investigations of Bucha, Mariupol, and all the other horrors that have happened. Are we willing to accept that? Is that acceptable in 2025 as part of a peace settlement, that you down tools on all investigations of crimes committed during the occupation? So these are not hypothetical future issues in what we care about in terms of the rule of law and the kind of world that we live in. They are real hard issues that politicians and diplomats and legal advisors are having to address right now. What are you willing to accept for a peace deal in relation to Ukraine and Russia? What are you willing to accept in relation to a peace agreement between Israel and Palestine? What are you willing to accept in relation to peace in Sudan? All of these questions, and a myriad of others, raise questions about the international legal order, how it functions, and the compromises we are willing to make as we go forward. And they're really difficult questions. They're not easy questions. Anyone who says to you, it's really simple, this is what you have to do. Actually, it's not really simple. It's complicated people's lives turn on it, people's sense of well-being turns on it, people's sense of justice and injustice turns on it, and these are really big issues that we are grappling with right now, and they're not going to go away.
Yeah.
Thank you so much for joining us today, Mr. Sands, and thank you to the audience for listening.
Thank you very much indeed. Thank you for having me. Thank you.